Assalamualaikum warahmatullahi wabarakatuh. So, welcome to another lecture for Law of Thirds 2. So, for today, right, for this lecture, we are going to discuss about interference with goods. Actually, it covers trespass to goods. So, this is another discussion on another lecture on trespass. So, in the earlier parts, in the previous parts of the lecture, we have covered together trespass to person, okay, assault, battery, and false imprisonment, as well as trespass to land. Okay, so for today, this is the third one, which is also on trespass, but the broad topic is interference with goods, which covers actually trespass to goods as well as conversion. Okay, so that's why, like I said just now, so basically, for interference with goods here, okay, it can be further divided into two, which are, the first one is trespass to goods and another one is conversion. So they are quite similar and they could be overlapping here and there, but then they are also different. So because they have different elements for these categories of parts here. And take note that actually what's the purpose of the thought? Okay, we want to know what's the aim, okay, the objective of the thoughts here. So basically, the emphasis is on protection of property rights. So whatever rights which is attached to property, so it is protected by these kinds of thoughts. It's either trespass to goods or conversion. Remember, we are dealing with intentional thoughts. Okay, trespass to good. So let's define the word here. Okay, trespass to good. So basically, it is defined or it refers to any act of direct physical interference. So it involves something which is physical acts which interfere with the goods in plaintiff possession. So that's the important word, the keyword possession, without lawful justification. Okay, and then there comes the methods or the ways, the modes it is committed, whether that be by taking the goods from him or damaging the goods without removing them. So taking involve removal, but if you damaging here, may be no removal, no taking, no acts of taking, but just damage, okay, or destruction to the goods. So it all comes under trespass to goods. Okay, right. I have to move the camera. Okay, basically because we are dealing with intentional thoughts here, so plaintiff actually, I think I better put it here. Okay, must have had the intention to interfere with plaintiff's good. The intention must be there. After all, this is intentional thoughts, and then because of that, because of the requirement of intention here, inevitable accident will be a good defense to any action for trespass to goods. If the defendant can successfully successfully prove the elements of inevitable accident, then there will be no, there won't be no liability on the part of the defendant. For example, in the case of National Coal Board and Events, this is a common law, 1951. So defendants' employers, they were doing some excavation work. And then in the course of doing this work, they accidentally, so that's the word, accidentally damage plaintiff electric cables. So the cables belonging to the plaintiff, all right? And now plaintiff suing defendant for trespass to goods because of the damaging, okay? The act of damaging here. But the court held that there was no trespass. Okay, why? Because the act was accidental and it's not intentional. So rather than suing under intentional thoughts, okay, so maybe plaintiff here has to sue under negligence. Okay, remember negligence, no need to prove intention. But again, you have a different requirement for negligence. Okay, now let's go to, all right. Let's go to the elements. So basically, from the definition just now, we're able to extract the elements. Okay, so altogether there are at least 3 elements here. Okay, the first one, the plaintiff must prove it is a wrong against possession. I mean, it relates to possession and of course not ownership. We are going to discuss after this, okay, one by one. Second element is direct physical interference. So it requires something which is physical. And the third requirement is without lawful justification. Nothing in law which justify the act, okay, of physical interference. Okay. Alright, the first element, wrong against possession. So basically, remember when we discussed trespass to land also, okay, we talk about the concept of possession. So basically, trespass to goods, or the acronym is TTG, is essentially a wrong against possession and it's not against ownership. So there's no need to prove elements of ownership. So here, those who possess the goods, okay, not necessarily the owner, but it could be the owner, it depends, okay, but no requirement of ownership so long elements of possession is proved. And then as far as the plaintiff is concerned, okay, plaintiff must have been in actual possession. So he possessed the goods, okay, when the interference occurred, okay, when trespass to goods occurred. Second element, direct physical interference. So interference here must be direct. It was the defendant who caused the trespass, the act of trespass here, okay. It caused physical contact. So there must be certain physical contact, application of force here, right? Application of force by which the property is moved from its, usually it needs certain force for you to move the place or even force to damage the goods, okay, all right? So it all the requirement, okay, for the second element. Okay, let's have a look at the case. This is a common law landmark case actually on trespass to goods. Kurt and Gregory, this is appeal case, all right? After appellant's death, okay, appellant's sister-in-law, so she removed some jewelry, actually rings, okay, certain rings, okay, from the room where the he was lying, the appellant was lying dead, okay, to another room, thinking that the act, okay, actually the acts of removal actually to protect the jewelry, the rings here, okay, thinking that to be safer place, meaning that you're from this room to another room. But if you read in if you read the report, actually the room was unlocked, okay, and then the another room also was unlocked, so it's not really safe, okay. So from the room that she has removed, okay, the room that she has kept the jewelry, okay, from there the jewelry was stolen, okay, and later the appellant's executor, because now appellant was dead, okay, so the executor now sued appellant's sister-in-law, okay, for trespass to jewelry, okay, all right, because there's physical act, okay, by the sister-in-law, okay, force, I mean removal, all right. So the court held that yes, removal was physical interference, and then as far as the case was concerned, okay, interference was not reasonably necessary. After all, she removed from one unlocked door to another unlocked door, so it's not reasonably necessary. So the acts of removal, it amounts to trespass to goods, trespass to the jewelry. Okay, another requirement is without lawful justification. Okay, so if defendant's interference, the act is justified by law, then he will not be liable for trespass to goods. No liability if he can prove that actually the act was justified, was allowed by the law. Okay, all right. We have the case of Creswell and Searle, common law, 1947. Plaintiff dogs, okay, chased defendant's sheep. So defendant was the sheep owner. Okay, he owns certain sheep here. So the dogs get chased defendant sheep, and then the sheep was pregnant actually, so causing the sheep to miscarry. So to protect the sheep, in defense of his sheep here, okay, defendant shot one of the plaintiff's dog. Okay, all right. So later, defendant was sued by the plaintiff, okay, for trespass to goods for shooting the dog here. But the court held that defendant's action was justified because why? The sheep were in real and imminent danger. After all, the sheep has miscarried later, okay, and that any reasonable man in that situation, okay, would do the same. One word is missing, would do the same, okay, if placed on defendant's position. So because of that, defendant was held not to be liable. If you remember, okay, when you were in your part one, okay, of thoughts, okay, you discussed about general defenses. So I think the case will come under the defense of necessity. So here it justified the act, okay, lawful justification. For local case, okay, we have the case of Haji Awaluddin bin Anidin and Majlis Perbandaran Kuantan. What happened here? Defendant MPK, right, the local council, so under a statute, so defendant issued a notice to one Chua. Okay, that's the name. And Chua actually owns certain premises here, and a defendant, the MPK, right, required Chua to pay areas of assessment due within 15 days. there's certain tax pending, okay, not paid, unpaid tax here. Since payment was not made, okay, even after the notice lapse, okay, after 15 days, so MPK, the local council, proceeded, okay, to remove a cassette recorder and a TV set belonging to plaintiff. So later, belonging to Haji Awaluddin, later the goods were returned to plaintiff, okay, when Chua paid the arrears to defendant. So I believe Haji Awaluddin is the tenant lah here, alright, in the premises. So now plaintiff sued defendant in trespassing the goods. The goods were cassette recorder and TV set. And the court held that actually, when defendant did the act, proceed to remove the removal or confiscate temporarily. Okay, actually, defendant had complied with the law. Okay, certain statute which allowed that to be done, that empowered them to seize the goods. Okay, that's the word seize, seizure. Okay, in such a situation, because why no payment of tax was done? Okay, the pending payment. So the seizure was actually allowed by law, was lawful, and no trespass was committed, no liability on the part of MPK. Okay, we are done with trespass. So just a short discussion. Okay, and then we have discussed both elements. Now we go to another category of interference with goods, which is conversion. Okay, just now trespass with goods, and then higher degree, which requires more things to be proved. Okay, is conversion. Why the word conversion? Okay, conversion from the word converts, obviously. So it means, okay, to use goods owned by another person as your own, which is to convert it. So it is conversion. So it's about converting, okay, the rights over the goods, okay, asserting the rights. That's why it amounts to conversion. Because in Malaysia, we also have we also use the term conversion for to refer to change of religion, okay, conversion. So this is the definition for the conversion, okay, an intentional dealing with goods, obviously, okay, of a person. It requires intention, the goods of a person, which constitutes an unjustifiable denial of his right. That's the keyword, denial of his right in them, or the assertion of rights inconsistent therewith. And then this is the way it is being committed here. It may be committed by wrongfully taking possession of goods. You take possession of goods, okay, the defendant take possession of goods, or by wrongfully disposing, okay, wrongful disposal of the goods, or by wrongfully destroying them, okay, damaging them, or simply by wrongfully refusing to give them up when demanded. Meaning that, yeah, initially you have the defendant has the right over the property, the goods, but later when the owner, the one who has the possession, asks for the return, defendant refused to return. Then from that moment onwards, so it amounts to conversion. Okay, let's move further. So this is actually the elements. Okay, try to compare with the elements of trespass goods. Okay, so it's quite different. Okay, especially the second one. Right, the first one, intention. Of course, it requires intention because we are dealing with intentional thought. So wrongful intention is not necessary to be proven for conversion so long there is intention to commit the act. It doesn't have to be wrongful intention. And then the second element is denial of plaintiff right to goods or assertion of an inconsistent right. Okay, we're going to discuss one by one all the elements here. Okay, the first one, wrongful intention is not necessary. So yes, because why? The emphasis is on the act, okay, not really on the intention. So long the act is intentional, then yes, the first element is considered fulfilled. So defendant, okay, may be in some situation, may be totally and blamelessly ignorant. He doesn't know, okay, but even though he committed the act intentionally of the honest interest, okay, in the goods and still be liable for conversion. So the most common, the most relevant situation is whenever it involves stolen property. So a purchaser of stolen property, okay, commits conversion against the true owner by taking delivery of it. So whenever a person buys, okay, or even take possession of the stolen property, even ignorant, without knowledge, okay, but then there's owner of the property. So of course, this is an act of conversion, even though no intention to buy stolen property. Because in this situation, ignorance of law is not excuse. So whenever it involves stolen property, the primary right, okay, remains with the owner. Okay, let's another relevant rule, okay, which to conversion here, okay. Good faith is no defense in an action of conversion. Mean that here, just now you said, oh, no intention to do conversion. So can you actually use the defense of good faith? Usually, no, no good faith whenever it involves stolen property. But again, it depends on the situation. Generally, no. Okay, the case is Hollins and Fowler. This is appeal case, decision by House of Lords, common law. What happened here? A rogue fraudulently obtained possession of cotton. So the goods involved here is cotton from Fowler and sold it to Hollins. So Hollins is the new owner, who actually purchased the cotton, from the rope. And remember, the owner of the cotton was Fowler. So Hollin, the purchaser, was ignorant of the fraud, which was committed because he was dealing with a rope. And then Hollin sold and delivered it to another party, M. But M is not a party to the case here. So the court held that Hollins, who was liable in conversion to Fowler, even though he had acted in good faith. So in this situation, the emphasis, the highlight is good faith, on the part of Hollin, it's not the defense, which was accepted by the court here. So this is the analysis of the case actually. The principle which we can actually learn from the case is that any person who obtained possession of goods of another, who in turn has been fraudulently deprived of them, Fowler, and subsequently Hollins, subsequently dispose of them, whether for his benefit or otherwise, is liable for conversion. So that's exactly the illustration of Hollins Fowler just now, especially if the defendant himself was directly involved in the business negotiation. So here in this situation, Hollins was the one who directly involved in the negotiation to buy to purchase the cotton from the rope. So okay, however, but there's certain qualification here, right? However, if someone else had been directly involved in the business transaction and the defendant is merely an agent, all right? Let's say we just change a little bit of the facts just now, for example, Hollins was merely an agent, so he won't be liable because why? He was not involved in not involved directly in that business transaction. Right, the last one. So, plaintiff in Hollins and Fowler could not take actions against the purchaser as he was a bona fide purchaser. Okay, M. Remember M, the property passed hand to M already. So M in that particular case in Hollins and Fowler was actually bona fide purchaser for value without notice. Okay. So for that one, we have this case. This is the rule, the ratio of the case. Chedin Muhammad Hashim. This is local case. Teo Ong Tor and Chiu Chan Sang, 1950. The court held that the rule that we can extract from the case, bona fide purchaser for value in that particular case did not acquire a good title. Why? Because he and the seller knew. So elements of knowledge was there. Knew at the time of the sale that the seller had no right to sell the goods. Remember requirements? Bona fide purchaser for value, yes, you paid, and then without notice. So in this situation, with notice, he knew. That's why he doesn't acquire a good title. Another relevant rule, here, to the rule just now, all right, Nemo that rule, which means a person cannot give a better title than what he has to someone else. If the person has a defective title, he can't really transfer the defective title to the next person here. Exception, to bona fide purchaser. But if the next person is bona fide purchaser for value without notice, then yes, he might. He will acquire good title. But if we just case just now, with knowledge, with notice, then no good title. The title is not valid. So if the goods were bought in good faith, the true owner will lose his right and title over the goods. The first owner, once the property pass hand to the purchaser for value without notice, then it's too late for you to get a return of the property. But you can actually sue the person who passed the goods to the purchaser for value without notice, like Hollins and Fowler. Okay, another case is, this is another common law case, Morgate Mercantile Company Limited and Finch and Reed. It involves hire purchase. Okay, hire of a car under hire purchase. So he's not the owner. Okay, he's just a hirer. Usually, if you buy a car, okay, from a financial company, okay, it's under hire purchase agreement. So you are considered as hirer. You are not the owner unless you have paid all the installment, okay, for the full amount, okay, of the loan. All right, so the hirer of a car under hire purchase agreement, so he lent the car to respondent, okay, and then unknown to the lender, okay, the hirer of the car, okay, the owner, quote unquote, to the hirer, respondent used the car to transport uncustomed watches, which is illegal against the law. Okay, you're supposed to pay tax, okay, for the watches. And then the car was forfeited, okay, and sold by the custom authorities. So that's what happened. Now the finance company, the real owner of the car, because remember the car still belong to the finance company, not it doesn't belong to the hirer. Okay, the finance company brought actions against the hirer, okay, and respondent for conversion. And respondent, remember, he's the one who caused the seize of the car, actually, okay, the seizure of the car. So the defendant argued that when he used the car, he said no intention. He doesn't have intention that the car to be forfeited by the custom authorities. Yes, he has intention to do the dealings, okay, with regards to the uncustom watch, but then no intention on respondent part for the car to be forfeited by custom authorities. That's the difference, okay, which was argued in the court. But the court rejected his argument, and the court held that respondent, the one who was responsible for the act, okay, must be taken to have intended. We assume, I mean, the court assumed, okay, that the forfeiture of the car, which was the natural and probable consequence of his conduct, because he was involved in illegal conduct, and that his act actually amounted to conversion. It's no difference that you have no intention and the car might be forfeited. Of course, this is something which is probable and natural. Okay, so this is actually the court decided by way of making the obvious assumption. Okay, this is something which is reasonably can be presumed. Okay, we stop here. We are going to continue with the next part of the lecture, okay, with the second element of conversion. So I'll stop share. Okay, that's all. Thanks a lot for listening. Hopefully you have been able to follow and digest today's lecture. So until then, Assalamualaikum warahmatullahi wabarakatuh.